All right, let's get going. Before we get started, just some housekeeping. The structure of this call is going to be 45 minutes overall. The first 30 minutes will be a discussion with Sarah and her 500 words approach to contracting. We try and leave the last 10 to 15 minutes available for any open questions and answers. The recordings will be made available at the end of the webinar. We will exclude the questions from that recording, but everyone should receive a link via email. We've also got some polls that might come up during the course of the conversation. It would be great to get everyone's feeling and views on a couple of things, especially around the topic that we're discussing today. Initial introductions. My name's Dylan Fillion. I'm a senior legal advisor and practice lead at Radiant Law. I oversee several teams that help deliver our services to our clients. Radiant Law, we're known as a ALSP, or a alternative legal service provider. It means a lot. If you Google it, you'll get a lot of different answers. But effectively what we do is we provide managed legal services and more focused project work to large corporates, helping them improve their contracting process, and hopefully closing agreements at the end of the day. Our main ethos as a company and as a law firm is to create great relationships. And one of the key principles is having clear, concise, and reasonable terms. And I think that's a good starting point for any relationship. And that very succinctly brings us to Sarah Fox, our guest today. So Sarah, in her own words, is a recovering lawyer who believes contracts should be simple enough for anyone to use. As she said, after dealing with complex, costly contracts, she has developed her 500-word contract approach, helping teams streamline deals, build trust, and save time without sacrificing protection. A hefty task, no doubt. A noble pursuit as well. That's one that Radiant definitely gets behind. Sarah, welcome. Thank you so much for joining me today. Really excited for the conversation, and handing over to you if you want to tell us a little bit about yourself.
So I suppose when I say I'm a recovering lawyer, I've been a construction lawyer for 30 years, but I'm technically speaking a non-practicing solicitor. But that seems just a bit too long for somebody who likes things in 500 words. So I've been a construction solicitor. I'm also a dual qualified trainer, and I think partly the training element was what got me so interested in reducing the length of contracts, because I saw the real impact it was having on people who had to use them every day and actually didn't know what they were doing. And when they spoke to their lawyers, who I was also training, they couldn't explain it simply either. So that kind of began to make me think maybe all those reams of paper weren't such a sensible use of our time, energy, and efforts.
No, definitely. I think we still see it today. The contracts are incredibly long. You're lucky if you get one that's shorter than 50 pages nowadays. So I think approaching it from a 500 word perspective is quite unique and definitely eye-catching. I mean, I don't think I've seen NDAs that have used only 500 words. So what made you come up with that idea, and how difficult was that approach?
So I, at the time, was working as a professional support lawyer and had set a 1,000-word assessment for some of the construction lawyers that we were coming across. And interestingly enough, I was looking at it and judging them and trying to kind of see what they'd missed. And some of them were huge misses, like the scope hadn't been referred to at all in those 1,000 words. And interestingly enough, what I found was the litigators tended to be, or the people who tended to do more litigation and court work, tended to be better at drafting this in 1,000 words, because they didn't have any predisposed ideas of what was needed in a contract. So they didn't try and take a big contract and make it smaller. They just started from scratch and kind of worked out what you needed. So they tended to be better. So I thought, well, if I've set 1,000 words for other people, maybe I can do even better than that. Maybe I can get it into 500 words. And 500 words just seemed like such an outrageously small amount of words, because it's literally one side of typed A4. That I thought, well, it's a challenge. If I said I can write a contract in 2,500 words, it kind of doesn't have the same ring about it. And maybe I think this was about the time I'd read Seth Seth Godin's book on purple cows, and I thought this is probably a purple cow if I had it in 500 words. So yeah, so you asked how difficult it was. Oh, ouch, really difficult. The first one I did was on letters of intent because I'd written a paper, an academic paper on this, and a paper that was published by the Society for Construction Law. So I understood them, and they're short, simple, temporary contracts. Then when I went to consultant appointments, it got harder. I think my first draft was over 1,000 words. And then subcontracts took me about 3 years to try and work out how I could get a contract in 500 words that was a good subcontract. So yeah, it's been a journey, shall we say. And I know that's an overused word, but it has taken some real effort to try and get it to 500 words and just 500 words.
I mean, what was the feeling from the industry when you kind of came forward with this approach? I mean, I'm suspecting a lot of hesitance, a lot of no ways, that's not possible. Yeah, but we really need this clause in here. Yeah, how did you handle that, and what was the feeling?
Well, it was really interesting because one of the first lawyer friends I gave it to said, "This can't possibly work." It's like, okay, that's, thanks for bursting my balloon really early. But fairly soon after I started talking about it, the chair of the then Joint Contracts Tribunal, who was a bloke called Peter Hibbert, wrote a paper that said, some people might think a page of A4 would be sufficient as a contract, but there's just simply not enough trust in our sector. And that made me start wondering which came first. It's a kind of chicken and egg approach. Does shorter contracts drive trust, or does trust drive shorter contracts? And that, for me, was almost it was a real challenge, because he basically said, you can't do it. And he wasn't the only person who said, you can't do it. But actually, most of the feedback from lawyers privately was, God, I wish we could do it like this, because we spend hours and days and time in meetings and on emails and stuff talking about dotting the I's and crossing the T's on clauses which nobody will ever look at again. So there's a real disconnect between publicly what people were saying and privately what they thought clients wanted. So that was just really, I knew there was no solution to that.
No, I think, and trust is such a big point, because I think inherently a lot of our templates, they get developed because trust was broken at some point, and it's not with the people that we're actually trying to create a relationship with. Dealing with a situation where it's like, no, we need to make sure that you're not illegally trading gold or something, and it's like,
yeah. We've all read terms from maybe smaller businesses where we can almost read the history of all the things that have gone wrong with previous clients in the past, because there's a clause for every single one of those things. And you just think, but I'm not the person who ripped you off, who, took your bicycle, or, whatever it is. I'm not that person. And treating me as if I am doesn't come across as very, as very fair or very trusting.
It's not a good start for what's supposedly a good symbiotic relationship between two entities. At the end of the day, you're all working towards the same goal, and I often you get your backup. You get a long agreement, and it's like, well, is this how it's going to start?
yeah, and not enough people are prepared to turn around and say, I'm out. But I have had people send me, even though they know what I do, really long documents saying, just sign it, send it back. I said, no. First of all, it's too long. Can we shorten it? This is my proposal. And if they say no, I said, well, I'm out. I'm not prepared to work on those terms. I don't work for you. I work with you. If you want to work with me, that's fine. But let's make it more collaborative and based on trust.
What do you think are some other reasons that still in this day and age, when we're supposed to be moving faster, it's all about efficiency, it's same day turnaround, why do we still have this culture of long, complex contracting?
Well, it's interesting because the culture has changed, because when the JCT first produced their first contract, it was 25 pages long. It's now over 100 pages. So that's the contract that's now 4 times as long. And I think some feedback I've had is it doesn't feel legal enough because it's not thick enough or jargony enough. It's like, hang on, all I'm doing is recording a deal. Your deal wasn't talked about in jargon and in long, complicated terms. So, there's a real disconnect basically what we've ended up with is a commercial deal and a legal deal, and they don't really kind of match anymore. So we have all these provisions that are very legal based, and we have very little that's actually process, project management, or contract recording. So we've kind of just ended up with too much content that's legal, and people are afraid to get rid of it, because what people say to me is, oh, well, it must have been in there for a reason. It's like, okay, but is that reason good enough to keep it still? Does it still apply? Is it relevant to this relationship? Is it relevant in this fast moving, innovative culture that we've got to, where we do everything on our smartphones? And, 20,000 words, nobody's going to read 20,000 words on a smartphone. 500 looks like a lot on a smartphone. So I think there's still the copy and paste. It's been in there before. It's tried and tested language. And, Ken Adams, for all his discussions, he's a commentator on contracts and all this kind of stuff. Tried and tested means it's failed once. That's why it went to the court, And there is still a kind of comfort factor that people feel from longer contracts. They believe they're watertight. They cover everything. There's no gaps. Time and time again, the cases would show us that's absolute rubbish. But it's a trope that's really difficult to break.
Yeah, it's like a shift in conscious of like the entire industry, and we need to move away from that. I mean, you see it all the time when these deals get so long and so complex, they end up contradicting each other. And something that you've agreed at the front end, and by the time you get to page 55, you've actually forgotten that that was already addressed. And so you're dealing with this backlog of historic safety measures, historic precedent, and it's really hard for sometimes to justify those positions, which makes negotiations even harder. And then also to justify why we're removing it, because again, like you said, it's clearly in there for a reason. So, I mean, in your view, what's the biggest myth about long contracts and safety that we kind of need to overcome?
I think the biggest myth is that a longer contract covers more stuff and therefore it's more watertight. Now, 2020 should have taught us otherwise, because millions of long contracts worldwide said nothing about a global pandemic and the restrictions that might be imposed by governments. So therefore, we know that they're not comprehensive and they don't cover everything. But the biggest myth is that it's helped this deal. And generally speaking, they're signed in order to meet some compliance or internal governance issues, and then they're forgotten about. People do not read those contracts. So we think we're trying to be helpful, but the only time those contracts are going to be read in detail from cover to cover is if you end up before a court. Now, the other myth is that a lot of things end up in dispute. Well, World Commerce and Contracting data shows that less than something like 0.02% of contracts end up going to lawyers for an opinion. Not even in court, but get to the point of a serious legal dispute. That's a vanishingly small amount. So why are we drafting contracts as if every contract will end up in front of a bunch of lawyers? It makes no sense.
We're drafting something by lawyers for lawyers that end up the business team having to live with day in and day out. And, that over complexity it makes everyone's job harder at the end of the day. And I think it's a very fascinating statistic in terms of what actually ends up in front of a court or in front of a lawyer even. It's because, again, we're working towards building a relationship, and you more than likely want to maintain it or you want out. I guess it's...
And big companies like Amazon are noticing this. They've realised that their over-lawyered contracts are stopping them working with small startups, with innovative companies, with anyone without an in-house legal. They realise that they have commercial clout, so that actually they don't need the contract. The contract is not their leverage. Their leverage is continuing to work with a global, multi-billion, trillion-dollar company. So therefore, the contract has started to become less important to some of these big companies. So I know that a number of those really multi-big companies have just said, right, we need a 4-pager for dealing with, fast transactions where we're dealing with innovative people, so that we can just reduce what's called deal velocity, the time taken between saying, I want to work with you, and being able to work with them.
Yeah, I mean, the fact that you kind of establish this commercial understanding between each other, and then it's like, okay, but give us 7 months. We need to get the contract in place. It's not efficient.
No.
Um, I think safety is a big point that everyone has a concern, especially when hearing 500 words. How do you approach that? How do you make sure that you are securing your client's best interests?
So one of the things I did when I did the 500 words was work out the 10 essential things that you needed in a contract to reflect a deal. So it was things like who the parties are, what they're doing, when they're doing it, how much they're going to get paid. And then you need the processes to do with, changing, limiting liability. I put in what the aims of the project are, which is weirdly something I often don't see in even longer contracts. A clear sentence that says, we are looking at, the most important thing to us is time, cost, quality, or whatever. So I wanted to I went on the essentials and then what would make it workable. And there is some reliance on local jurisdiction law because it's very difficult to put everything in that you want. But I work in construction. An awful lot of construction contracts have a bigger set of appendices than they do the terms and conditions, even though the terms and conditions are, as we've discussed, pretty long. All the documents that describe how much they're going to get paid, what works they're going to do, the quality standards, the testing regimes, the program, they're all written by somebody else. Lawyers shouldn't be playing with the stuff that's already been well written by someone who understands this stuff really well. So, I think, relying on the parties to get the commercial, the operational, the technical backup is the core of any construction project, and we have to rely on other people to do their bit so that we can just kind of provide a framework into which everything else slots. And taking that kind of more frameworky approach, making processes as simple as possible. It is one of the things that I would, if I had a long contract, I would check first, the long processes, because if you dictate a process, two corporates have already got their payment systems, they've already got their mechanisms for doing change, variation orders and all this kind of stuff. You dictate it in a contract, you can sign it as much as you like, but that doesn't mean that your internal teams are going to change all their software to do it. So it would be the first thing I would look at, because they're often very long, very complicated, and wholly ignored.
Yeah, you kind of just sign it. It's like, oh, we'll get paid, and it's like, okay, but there's this invoicing process, and you actually need to do this. And you've got to submit it via that, and it's often overlooked. So yeah, when I guess first thing you look at when you're doing the contract is what's the first thing you take out that you see time and time again in a contract that it's just not necessary?
So often I will look at boilerplate clauses, but they're right at the back. They're the least important things. One of the things I want to do is take out the information about the project and put it in a table right at the front. I know Verity White talks about something called the reverse contract sandwich. It's basically, I'd like to know what the parties are doing in simple terms in a piece of paper I could stick on my fridge or open on my smartphone and just have it summarised. Definitions and interpretations, I will try and get rid of and minimise as much as possible because they really disrupt our way of being able to understand the flow of a document. I would try and minimise all that kind of stuff. But fundamentally, I want a process that's simple and sweet. And also, I don't want a whole load of compliance, particularly with local authorities in the UK. You see the modern slavery, you see the freedom of information, you see data protection. They're all laws that they have to comply with. If they have policies, chuck it in a policy, have it as a reference, but don't put it out word for word and pages and pages and pages in every single document. So I think we just have to think differently. We have to kind of get away from legal headings of modern slavery and all this kind of stuff, or copyright or data protection. Go, how do we share and use data and information? And, how do we change this project or this contract or the timescales? How do we do all that? Because we know that plain language requires you to be able to find what you need quickly. And that's a real core thing that's missing from a lot of construction contracts or any contracts, because there's no kind of order to where everything is put. It's just kind of like the parties, and then it might be the contractor's obligations. Then you might be sharing data. Then you might have something about, I don't know, modern slavery. And then you might have payment. And it's like, whoa, 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 whoa. Surely payment has to come quite early, because that's the thing that most people are interested in. So all that kind of information architecture, the restructuring. But, when you ask people what's important to you about this contract, where have you had problems? You can then see how much of that content actually doesn't address their business values, their strategy, the way they operate, their actual client issues. And if you say to them, can we get rid of this? Often they go, yeah, we don't even know why it's in there, but we feel like we ought to keep it because probably someone. It's like, yeah, okay, the probably someone answer.
So, I mean, especially working with clients, and obviously giving an example there where they're like, "Oh yeah, no, it's fine. We don't know why it's there." But I mean, how do you approach that conversation, and how do you get someone from point A to point B in terms of you don't actually need this, you can live without it, or it's sufficiently addressed just by having an acknowledgement that we're going to comply with law at the end of the day?
Yeah, well, a lot of it is, how much of this do you think changes behaviour? Because if a statement doesn't change your behaviour, then it's probably covered somewhere else. It could be in laws, it could be in case law, it could just be in a general statement about acting professionally or with reasonable skill and care. If it doesn't change your behaviour, it's just extra information. It's kind of padding for the sake of it. So I kind of look at, does it change behaviours? Does it drive meeting the business objectives? Because if it doesn't do either of those two things, it's probably not going to come up very often. And I know, there are occasional cases to do with commas or entire agreement clauses, but I've looked at a lot of the case law and I've seen parties have to stand before judges and hear them going, why is this clause in, Mr. Whatever your name is, Mr. MD? And going, well, I haven't actually got a clue. It's like, well, why is it in there though? Well, I don't actually have it. It doesn't look good. So, the idea that you could have a client that has to stand up and talk about a contract that you've drafted and not know why it's in there means that you've got to take a slightly different approach. So even though I don't think much goes to court, I also want people to be able to stand up and go, I know exactly why all this stuff is in my contract and what it means, and I will stand by all of it. I don't want anyone kind of acting a bit lily-livered and going, well, Sarah put it in and I don't really understand it.
Yeah, no, I mean, it's such a valid point, and you often find yourself asking those questions and being met with blank stares across the room, like don't know, and it's like, this seems like it should be something that's it's kind of critical to why it's in your contract, and I can't fight for this if you can't tell me why you need it.
Yeah,
it makes everyone's job a lot more difficult at the end of the day. I think this will be a good opportunity for Enzo, if you want to share the poll with the group, just so we can start getting those insights. We've got some questions there from the team. So give an opportunity for those to come in. While we were waiting for that, I think a big question, Sarah, is how does simpler language in contracts help build trust with clients or suppliers?
Oh, so, this is, I think simpler language helps people to be able to, generally speaking, they can read the contract. So they can check it, because if it's simpler, it's not going to take up too much time. They're not going to feel like they're going to have to get a lawyer involved. If they can read it, they can spot that whether or not it records their deal properly and accurately, because they should be able to identify the things that they've talked about in previous negotiations and see where they've appeared in this contract. They'll also be confident that there's no small print, for want of a better word, or hidden nasties or wriggle room, the sort of thing that just turns up in contracts on a regular basis and they're kind of expecting. So if you don't see something negative that you're expecting to see, that's quite a confidence builder. But if you can read it, spot that there's no small print and no nasties, if you can also understand it because the language is simple enough, it's not based on lawyers drafting for lawyers, it's people drafting for people, human to human, all that kind of stuff. But then if you can do both those things, then you should be able to work out that you will be able to use the contract. You will be able to use the processes in it. You'll be able to safeguard your business because you can understand what's required of you. You know how to manage the expectations. You can see what good looks like. You can get that result. Tick. We're all competent at what we do. But if somebody ties us up in knots, we feel like, I don't know, can I actually do this? You begin to doubt yourself. So actually, when you see it in plain language, you kind of go, yeah, tick, I can do that. That's fine. So, there's all sorts of ways that the language can make us more confident. One of the things I tend to do is write everything in the positive. So rather than saying what you can't do, Or it's like, you may not do this except if we give you consent. You said, you can do this with our consent. There's always different ways of writing it, so it seems more positive and more permissive rather than restrictive.
Yeah, no, it's so valid. You start reading a clause, and all of a sudden you're having to really digest it. You're jumping between three other clauses because this is reference, and oh, what's that definition mean? And then instantly your back is up, and you're like, something's not sitting right here. I feel like I'm under attack.
Yeah.
And it kind of creates that animosity already. It's the funniest thing when you look at a red line and then you join a call with the counterparty, and all of a sudden you're like, oh no, we're completely on the same page here, but it's because the language at the end of the day kind of got us both feeling a certain way. So we're like fighting over comments, but at the end of the day, we're looking for the same goal.
Yeah, and you rarely hear people say contract language causes issues, but we all have an emotional response to reading a document. Whether it's, your tax return or a letter saying that you've won £1,000 in a lottery or a contract, we have an emotional response, and we need to make that emotional response as good as possible. Otherwise, we end up in endless negotiations because they're hurt. And if they hurt, they will want to get revenge in some sort of way. It's just a natural human reaction. So whatever revenge is, for that person, and, maybe revenge is, I don't mean it in a really negative way, but I think, we all want to feel slightly more like we're on the front foot rather than being on the back foot. If you make us defensive, then we're going to act in an appropriate way. So let's make the contract less attacking and more balanced and fair and approachable.
Yeah. Otherwise, you end up in that situation where it's like, I'll agree to this point, but if you give me this point, and the 2 points have nothing to do with one another, and it's like, I'm not sure how giving that one actually impacts the fact that you'll get this one.
Yeah. So basically, we've turned into toddlers in a playground going, I'll give you my sock if you give me that conker. I mean, that makes no sense, does it, in terms of relationship building?
Definitely. Let's go through the poll results quickly, and I think a lot of what we expected to see. So, what's slowing down our contract process the most? Extended negotiations on one-sided terms. I think that is a big one. The approval process. I think definitely in large corporates, it's I can't give this away. I need to go and check internally. Any thoughts here, Sarah? I mean, in line with what you've
Yeah, it's really interesting. I was working with World Commerce and Contracting. They were trying to produce some kind of guidelines for a set of terms just for sales or buying standard goods. But they had two separate sets of terms. I said, but why? If we're going to start from the middle ground, then it can be one set to apply whether we're buying or selling. And that's a real head scratcher for most people because they're used to terms preferring one side or the other. But the reality is, after all those negotiations, we end up in the middle. So why don't we just start in the middle and save ourselves all that angst and time and putting people off from contracting with us?
For sure. What's the one thing you'd most like to improve in your contracts? Speed up turnaround. I mean, that's the big one. And I think a lot of what we're talking about lends itself to that actually happening, making them clearer, starting in the middle ground and being reasonable at the end of the day.
Yeah. Yeah, and there's good evidence that by simplifying contracts, you can speed up turnaround. Rob DeRoy, who's a South African lawyer, did an agricultural workers contract, massively reduced the onboarding process. I've worked with small clients who said, we've saved at least 75% of our time onboarding, and we get more yeses because we've made our terms simpler, because people read them and go, oh, I know what that means, tick. Even law firms will agree to my simpler sets of terms with their clients, so,
And then the last one, if you could change one part of your contracting process tomorrow, what would it be? And I think we can all agree, the negotiation stage, it's where all the pain is. It's a big one.
Yeah, and I think a lot of the negotiations are either caused because they didn't understand what that provision was meant, it didn't record the terms and the deal properly, or because it's very one-sided, which means we end up stuck in a cycle of email tennis with another lawyer, which frankly is no fun for anybody.
Yeah, thanks for that info. And I think off the back of that, I mean, what are the hidden costs that we don't see from contracts being too long or too hard to read and taking all this time?
Well, there's some really interesting data from World Commerce and Contracting who did the return on investment of contracting excellence. So they were talking about simplifying contracts. So I'm just looking down because I just can't remember this stuff, but they reckon you can reduce the contract negotiation time by 50% if you simplify your process and your content. You can get up to 60% reduction in your legal spend dealing with contracts, as in that's in the contracting phase, not in the disputes. About 60% reduction in disputes because you've got clearer terms, so you've managed expectations better. You get shorter timelines, so you get the whole project can be shorter because you understand the processes. But you've also got things like inefficiencies. The processes during the project can be made much more efficient if you've got a really clear, simple processes. So we've got things to do with, damaged reputation, profit losses from complexity. I mean, I did some kind of back of a fag packet calculations for a turnover company with about £100 million worth of turnover. And they were looking at easily saving 1% of their turnover by simplifying their contracts over each year, because there's so many hidden costs. And the thing is, we don't tot those costs up. We know that in construction, a third of projects start without a contract being in place, and somewhere about 3% finish without a contract being in place. Now, that doesn't sound like very much, but we do over £100 billion worth of construction work in the UK every year. So these are big numbers of projects that don't have contracts in place. The Arcadis Global Disputes reports show time and time again that one of the three main causes of disputes is people not understanding their contract. So, by simplifying, we've already got big wins. We can get into contract before we start the project. We're less likely to have disputes because we didn't understand it. Even if you just only take those two things, that's a massive amount of time, energy and effort saved by the parties involved.
Yeah, I mean, and that's seriously low-hanging fruit that you don't even see it because this is just how it's done, and you don't realize the far-reaching impact that has at the end of the day when you're spending months in negotiations and your disputes are not clear, and when something goes wrong, you don't the parties aren't aligned on what's actually written on the paper at the end of the day, and so.
But just to give you a simple example, I was called in to help a university whose estates department had got the standard construction contracts. They thought they understood them. They'd been doing a big multi-million-pound project on the campus, and the contractor, a year after practical completion, turned around and said, "Can we have our retention, please?" And they went, "What's that?" And they said, "The money that's ours that you owe us." And they said, "We haven't got it. We spent it. We thought it was ours." So, that sort of thing, it's comical when we say it, but it was devastating for both the contractor and the university, the university suddenly had to try and find several £1,000,000 from a budget that was empty, and the contractor needed that money because it was their profit margin. So, we know that standard contracts aren't actually helping any of the parties.
Yeah. If someone wanted to start trimming their current templates tomorrow, what's the first piece of advice that you'd give to them?
Start from a blank piece of paper. Trimming a template's really difficult because every time you see a clause, you think it's got to be in there for a reason. But also just speak to the users, speak to the clients and the suppliers that actually use this contract. Find out what they use it for, what their issues have been, find out what's important to actually get really clear in this contract, and then build back in the things that you like. Now, I've worked with people like the Federation of Master Builders and Finishers in the interior sector to deal with changing from one traditional standard members contract to a simpler one, and they really struggle often to let go of stuff. So I have to go in and just go, no, we have to get rid of this. This doesn't work. You don't need it, because it's really comfortable. It's like a teddy bear that sat next to their bed since they were a child. They really struggle to say this no longer has a purpose. So it's easier to start from a blank piece of paper and say, this is how we would like to structure it. Now let's see how we populate it, but start with some broad brush headings, formats, designs, look at how you can make it as user friendly as possible, because that's key. If you can make it user friendly, then the content will fall into place. But the reality is the degree of content is not that relevant. It's more to do with the relationships of the parties, the deal that was sealed in the first place. That's going to be far more important commercially than the I's and the T's and the force majeure or the severability clauses or whatever else.
I think at this point, I want to give it an opportunity to the attendees to ask any questions that they might have. I've seen a couple of thoughts coming in. Renee mentioned here that a common syndrome: commercial stakeholders blame lawyers for long contracts. Lawyers remind them they're happy to streamline terms. Stakeholders decline because they don't want the board to see them as cheerleading risk. So in short, colleagues are interested in pioneering conspicuously short contracts. I think it's something we come up against all the time. It's, you could sign it tomorrow, but these are the risks. But I need someone to be comfortable with those risks at the end of the day. And I guess it's a lot of it is down to communicating and how we get those risks across as well.
Yeah, but there's one of the cases that I referred to was a £9,000 contract done effectively on a purchase order and a bit of a standard bit of specification. Claim value was £110 million. So they did not address the risks of that project effectively in their contracting. So it's not actually about size, because a short contract didn't address the risk of that project. It was a standardization sometimes that actually is a bigger issue, that says you can use this for any sort of project. You can use, these are our standard terms. We have to be a bit careful with standard terms because they don't, then, we need guidance on when that's a good contract to use, what sort of projects you should not use it for. Yeah.
And just Renee, off the back of that, Ken Adams is a living treasure. We're big proponents of Ken Adams here at Radiant Law, and Sarah, it seems like you are as well. Simon mentions here, I think the bargaining position is highly relevant. I often deal with large multinationals who present unpalatable terms that need negotiating. We eventually end up in a middle ground, but they will never start at the middle ground. They just present their standard one-sided terms of sale purchase.
Yeah, and that's partly because they don't understand the impact it has on their suppliers. And I think often they just think, well, if you don't want to do it, somebody else will. And I suppose it does depend on how specialised you are as a supplier as to how easy it is for you to kind of take a stronger approach. But, if I've had very one-sided terms, sometimes I've just said, I'm not prepared to negotiate these. And if you're not prepared to meet me in the middle at the start, then let's just stop it now, because I have only a limited amount of time, energy and money, and I can't be bothered to spend it on your stuff. And that's a privilege that I have. So I know that it's not a position everyone can be in. I think, large corporates are beginning to see the costs of complexity. There's not quite enough change yet, but I think companies and associations like World Commerce and Contracting are really driving the idea that simplification is important. And their data shows that about 93% of corporates globally across different sectors are interested in simplifying. And I think most of them are hoping that Gen AI will do it for them for free, but hey, maybe that's another conversation.
Yeah. That's a can of worms. Gen AI is only as good as the information we train it on. And if we're training it on these kind of agreements, it's going to give us more of the same potentially at the end of the day.
Yep, completely.
Yeah, I think there needs to be a fundamental shift in how we think about these things.
Yeah.
And then one from Tara, maybe see an example of a 500-word contract. I think we are going to give out your links, Sarah, on email following this. I don't know if you have anything available, but
so you can, if you go to my website, which is 500words.co.uk, there is a section called Free Stuff. Sample contracts are on there. Contract checklists are on there. My books have all got wording for the 500-word contracts that they represent. So yeah, you can get hold of a sample of a 500-word contract. Feel free to tell me that you think I should put something into it, but at the same time, you have to tell me what I need to take out, because I only have 500 words.
And we wouldn't want your company name to be a lie at the end of the day. So
absolutely.
I think conscious that we're closing towards the end there, but a closing out question from my side is, what are the practical takeaways that you'd want people to consider when leaving this conversation?
I think practically is to try and get a grip on the cost of business as normal. Because that's the reality is that doing the same as we've always done is the simplest and cheapest option for most people. But understanding what that's costing you as a business is really important, because it's only when you can see the effect on your business bottom line that you're prepared to make changes. And it could be that you're losing clients, that you're losing suppliers, that you're not getting the best price from them because they've seen your terms in advance. It could be that your sales and marketing team are struggling to sell your products because their terms are just a bit embarrassed by them. It could be that you have no consistency across your business in terms of your values and your strategy. So there's all sorts of things that could be in the background. Some of them are difficult to quantify, but they're still important measures. But if you don't measure any of this stuff, how can you possibly tell that you need change? I know that the projects that World Commerce and Contracting have done, a lot of the people who've done simplification projects have said realistically, it's the best return on investment of any project they've done as an organisation. So it is a big change management project though. So getting the data to back that up is quite a useful tool. But start simple, start by taking something that you sign all the time, like an NDA, simplify it, see what the impact is, and then, assess it, test it, see for yourself whether or not the benefits are worth the effort that you've put in. But at the same time, understand the real costs of just the status quo, doing business as we've done business for the last 25 years.
Yeah, I think we all need to put that data together to actually be able to justify that change. And I think it's a worthy exercise. If anything, it'll help you identify the gaps in how you're approaching things and where you can potentially be doing things better, even if it's not just in the contract. So it's a good exercise that any company should be looking at. Sarah, thank you so much for your time, and thank you to all the attendees for joining today. Really insightful, and I've definitely taken a lot out of this. Sarah, I know you've mentioned your website where people can find out more about 500 Words. I think you're also quite active on LinkedIn, so go give Sarah a follow there. Anything anywhere else that we can find out more about your contracting approach, 500 Words? I think you've got a couple of books out there.
Yeah, so I've got a book site which is just 500words.co.uk, so that's just relating to the books and some of the resources that I provide for the books. You can download some free chapters from there as well. I'm on LinkedIn. If you look for either Sarah JV Fox or Sarah Fox 500 Words, you'll find me, no trouble. I'm not connected with the BBC 500 Words Short Story Challenge, but it's a common misconception.
Maybe there's some inspiration lying there. Thank you so much. Just from our side, we will be sharing an email following the call today, the webinar today, with all Sarah's links and some links to some Radiant resources as well. So keep an eye on your inbox. Always welcome to reach out to Radiant if you have any questions. We've also got a upcoming webinar on the 22nd of October with Ishan Salawar. He's going to be discussing practical advice on how to create systems that work across your team and also scale as you grow. So feel free to sign up for that, and it'll be great to have everyone join. But thank you again, Sarah, and thanks everyone for attending.
No, thanks, Dylan.